everyone. We're very excited to be here today at TCASE. Thank you so much for being here and being part of our presentation. Today we will be talking about maintaining safety in the school setting while meeting legal obligations for students with special education needs.
Take it away.
Okay, so we understand the extreme challenges educators experience when dealing with students who are disrupting the learning environment and exhibiting significant behavioral problems. We also recognize that many students may have regressed behaviorally during these unprecedented times of the pandemic. They got out of their routines, they were used to being at school every day with the structure and the friends at school, and all of that changed last year. And so that was a trying time for all of us, and especially could have been a hard time for our students with special education needs who have behavioral problems. And so during today's presentation, we will review the protections afforded to special education students and discuss various ways to address behavior needs. So in today's environment, student behavior that presents a threat to the safety could manifest in different ways. It could threaten the student, the individual student. It could threaten other students, campus staff, and campus facilities such as property. And so oftentimes when that kind of behavior occurs, it's likely to be met with immediate action to remove the student from the campus environment. But before we do that, we want to look at our student code of conduct. When you're proposing any kind of disciplinary conduct, we should start there to determine what's appropriate. It's important guidance to ensure we are treating students equitably for similar disciplinary conduct. And so our student code of conduct has several standards. It talks about the standards of conduct. It talks about the circumstances for removals, standards for removals to DAEPs, expulsions, suspensions, and it also gives consideration to different factors such as self-defense or did the student have intent when they conducted whatever act. And then it also looks at students' disciplinary history. So a lot of different factors that are discussed in the student code of conduct. We want to make sure our campus administrators are trained on how to interpret and apply the student code of conduct. There are several different disciplinary options available, from informal and formal teacher review, in-school suspension, out-of-school suspension, and then even DAEP or expulsion. And just remember that with those, there are certain conducts that they're mandatory DAEP removals or expulsion, and then there are some conducts where it's more discretionary and up to the administrator. And so anytime you're trying to figure out if it's a mandatory removal to DAEP or expulsion, consult the education code to get guidance on that, or your student code of conduct.
It skipped a slide. Okay, in the Texas Education Code, y'all know, is a little wonky because it says mandatory, but it's not mandatory because you have to consider those other factors such as self-defense, intent, a student's ability to appreciate the wrongfulness of his or her conduct, all those things. So that could change the range of discipline that you're looking at. Also, you have limitations in the education code. Under 37005, you're limited to 3 days of OSS. So you want to make sure that you're keeping those other things in mind. So threat assessments, y'all are familiar with this. This is something that was put in place under Senate Bill 11 a couple years ago. School safety and security were priority issues during the 2019 legislative session. And Senate Bill 11 was one of those things that emerged from that, and that's Texas Education Code 37115, addresses threat assessments, and that requires the district to establish threat assessment teams, they called them safe and supportive school teams, to serve at each campus and adopt policies and procedures for those teams, which are based on TEA rules and the Texas Safety and Security Center guidance. The team conducts threat assessments for individuals who make threats of violence or exhibits harmful, threatening, or violent behavior. This process is intended to be proactive. The goal is to prevent tragedy by supporting the students' social, emotional, behavioral, and mental health needs who show signs of harming themselves, others, or both. There are a few roles that must be included on each threat assessment team, and it's important to ensure that your team has individuals with this expertise listed here: counseling, behavior management, mental health and substance abuse, classroom instruction, special education, emotional management, and law enforcement. In most districts, the scope of expertise will require inclusion of professionals not employed by the school district. If the district uses an oversight committee to coordinate multiple campus teams, you then have to include members on that committee with expertise in education and human resources. So also, in addition to the core teams that are required by law, there are some other individuals you might want to consider including on that, and that would maybe be the student's parent, the student's mental health professional or provider, if any, and maybe a trusted school employee like a coach who knows the student well or on a personal basis. And a member of the team can have expertise in more than one area, so you just want to make sure that you cover all of those areas, and make sure that if you do have somebody who's external to the district, that they are accessible when a threat assessment team is put together when one is needed. So it's up to each district how they structure their threat assessment teams to just make sure that you meet those legal requirements. When considering threat assessments, you want to make sure that your team is trained. There are multiple I actually Googled this before we did this training. You can do these trainings online. They're available through the Texas School Safety Center or Regional Education Service Center websites. You have to conduct a threat assessment that includes assessing and reporting individuals who exhibit harmful, threatening, or violent behavior. That means verbal threats, threats of self-harm, bullying, cyberbullying, fighting, the use or possession of a weapon, sexual assault, anything that could be deemed threatening or harmful to that student, another student, or both, you want to address through the threat assessment team. And that could result in specific interventions, including mental health or behavior supports, in-school suspension, out-of-school suspension, all of those options that Ashley reviewed earlier. And when considering threat assessments for students who are bullying or cyberbullying, you want to make sure that you refer to state law there, or then that's going to be in your district policy FFI. And as all educators know, social media is a big part of students' lives, and unfortunately, it's an easy platform for students to engage in cyberbullying. And as you all know, this wasn't something that existed when I was a kid, and I'm certainly glad. I don't know how I would be able to handle it, but you want to take threats of violence seriously and consider the full range of options here. So what does the team do? The team gathers and analyzes data about the individuals and situations to determine the level of risk and appropriate interventions. And the analysis must consider appropriate information about behaviors, communications, unproven information. You can consider hearsay, any threats that were made, security concerns, relationship problems, any issues that may affect the individual. And I think that's where those individuals outside the school district might be really of great assistance in pulling together all of that data to get at the heart of what's going on with the student. The threat assessment team may also need to identify other individuals or students the person has interacted with or threatened. So again, check with the student's parent, check with the student's health providers, law enforcement, other students. Of course, you've got to be mindful of FERPA. Though the threat assessment team includes mental health professionals, those individuals, members of the threat assessment team don't typically provide psychological services directly to the assessed individuals. If necessary, however, the team will refer individuals for mental health support from another provider. And if the individual receiving the referral is under the age of 18, parental consent is going to be required on a district provided form that complies with law. So keep that in mind. You need to make sure that you get consent in making that referral, and maybe implement an escalation program as appropriate. The team also provides guidance to students and school employees on recognizing potential threats or harmful behavior. Once the initial assessment is made, the team will identify the best intervention to support the person's needs. The team is not authorized to remove a student from his or her educational setting, but the team's recommendations may be shared with the campus behavior coordinator for consideration in the disciplinary process. The team might consider contacting law enforcement, and of course, if it's a SPED student, the team will not be authorized to address a student's individual needs through an IEP or a BIP. But ideally, the team's recommendations would be communicated appropriately to the student's ARD committee so they can then review and consider additional behavioral interventions. If the team identifies an individual who is at risk for suicide or who has substance abuse issues, it should follow applicable district policies and procedures. And just for your frame of reference, your crisis intervention policy should be in your board policy FFB, legal and local. The threat assessment team should continually reassess the individual or situation to ensure that interventions are working and the individual is no longer a risk to themselves or others. And if necessary, the team will need to update its recommendations for intervention or support. Threat assessment teams have extensive reporting requirements. If the student or other person poses a threat of violence to self or others, the team must immediately report to the superintendent. If the individual is a student, the superintendent must immediately attempt to inform the parent. In addition, during an emergency, any employee of the school may act right away by calling 911. So the parental notice that's required does not prevent immediate action in response to imminent threat or emergency. The team has to report to TEA regarding the team's activities for each campus, including the occupation of each person on the team and the number and description of the type of threats, just more reporting requirements. The team must also report to TEA all of this information here, the total number disaggregated in various ways, Class C misdemeanor citations, the use of restraints, change in school placement, including DAEP and JJAEP, and all of these other things listed here. So extensive reporting requirements. More reporting. Additionally, the team must report the number or percentage of school personnel trained in best practices in suicide prevention, grief, trauma-informed practices, that's a big deal these days, mental health, psychological first aid for schools, training on safe and supportive schools. And I'm going to let Ashley take it over on talking about this.
Okay. So if the student who poses the threat is a special education student, the IDEA has various procedural safeguards that we must follow to ensure the student is getting all of their rights. And so in addition to a threat assessment that might be appropriate for a student, we would also need to do a manifestation determination review when we're talking about long-term removals. And we also call them MDR, so that's what I'll refer them as during this presentation. Okay, so with MDRs, that's a disciplinary consequence proposed that would remove a student for more than 10 consecutive days. If we do that, that's considered a change of placement for a special education student, and then an MDR meeting is required. The same can be true if there's a pattern of short-term removals. So even if it's not over 10 days of a removal, but it's a pattern of short-term removals, that might constitute the need to do an MDR as well. The ARD committee must meet to do the MDR within 10 school days of the district's discipline decision that would result in the change of placement. And make sure you provide the parent written notice, and of course schedule the MDR meeting within a time that's hopefully mutually agreeable with the parent. But again, we want to get that done within 10 days, 10 school days. So, and we have an MDR hypothetical here. You have a 17-year-old student who has emotional disturbance, attends general education classes with accommodations, has a BIP, has counseling as a related service. Okay, so let's say the student gets out of control, gets in an argument with his English teacher, which escalates, he curses, he throws his book on the floor, and then he doesn't stop there. The kid goes to a restroom, uses a permanent marker to write sexually explicit statements about the teacher on the bathroom wall. Okay, so that's bad, right? In this instance, we're of course going to first want to look at our student code of conduct, see what kind of discipline is appropriate, and for there, if the administration proposes DAEP for 45 school days, then that is considered a change of placement because it's more than 10 days, and an MDR meeting must occur. So let's talk a little more about what constitutes a change of placement. This sometimes confuses committees, and it's important to know that placement does not mean a particular school. It's actually the setting where they're receiving their instruction, such as are they getting them in general ed classes, special education classes, a special school, home instruction, or hospital-based instruction. That's what we're talking about when we're talking about a change of placement. So it's not necessarily because the student's going to a different campus. If they're still receiving the same services in their IEP, but just transferring to a new campus, then that wouldn't be considered a change of placement. Okay, so we'll look at some different factors for what constitutes a change of placement. As we stated, the MDR analysis is triggered when it's 10 or more days or short-term removals. So depending on the facts, a change of placement could potentially be suspension or expulsion under the education code, removal from school for just portions of the school day, bus removals, or ISS. So these next set of slides are interpretive legislative comments regarding removals, and we just think it's important to note some of them because, again, it can sometimes be confusing when determining whether an MDR is appropriate. So as we said earlier, portions of a school day may be necessary to trigger an MDR if a student's removed for portions of a school day, even if the student was not suspended for 10 consecutive days. So in this instance, we're looking at patterns. So for example, let's say we had a student with emotional disturbance and they were suspended for 2.5 days for insubordination in January, and then 5.5 days for leaving class early with aggressive behavior in February. And then the next month in March, they assaulted district staff and received more. In that instance, we would say that an MDR is required because in January, February, and March, if the student had very similar behavior, even though it wasn't consecutive and even though some of the days were just for partial day removals, it's still a similar behavior where they've been suspended in total of over 10 days. And so an MDR would be necessary in these circumstances. So that's something that I think committees often forget. Again, we just typically look at the times when a kid is consecutively suspended for over 10 days, but we want to look at patterns of removal throughout the year as well. So with change of placement for bus transportation removals, students sometimes fight on the school bus or exhibit other aggressive behaviors that jeopardize the safety of the bus driver and other students. And ARD committees should consider those types of removals from the bus when determining whether a special education student is entitled to an MDR. And so the Federal Register comments talk about that a little, and some of the legislative comments say, for example, if the student has transportation as a related service in their IEP and they are removed from the bus as a result of whatever it may be, fighting on the bus, in that instance, the bus removal would be considered a removal from school because the student needs the bus to get to school. They need to access their education through this transportation. So think about that too when we're looking at bus removals. And the case cited here is a case where a district was found to be in violation of the IDEA because they did not implement a student's BIP during transportation. And so sometimes it's easy to just think about implementing the IEP when the kid is, at school, but again, go to and from school, if there's some type of removal, we would want to look at the BIP, we would want to look at if an MDR is warranted. Okay, so change of placement with in-school suspension. An in-school suspension would not be considered as part of the days of suspension as long as the student is still receiving all of his or her special education services while they are in ISS. And so you want to make sure that they're still, the IEP is being implemented, they're getting all of their services, and they're able to participate with the non-disabled students to the extent possible. And I think the important tip for that is just to make sure everyone's communicating with each other and they actually know where the student is. If a child, for example, is going to be in ISS for the last 3 periods of the day and they have inclusion services, make sure that inclusion teacher knows where the student is so that they're receiving those services. If the student is not receiving their special education services during ISS, those days could be considered as a removal from school or a change of placement that would trigger the need for an MDR. This is a Texas case regarding change of placement, and it was with Texas City ISD. And the parents brought a suit against the district, a due process hearing. And the issue was whether Randy's assignment to ISS pending the resolution of the MDR was an inappropriate change in placement. The hearing officer held for the district and said no, because he was receiving all of his services while he was in ISS. So again, making sure everyone's aware and knows where the kid is and is providing services, then you shouldn't run into this issue. Next, I want to talk a little bit about preparation for the the MDR meeting. One thing that's important is that the administrator has a clear understanding of the behavior that occurred prior to the MDR. Make sure the parent has received a copy of the behavior incident. That's just all part of ensuring that the parent is an active member of the committee and knows exactly what occurred so that they can also provide their input at the meeting. And then the administrator should also have access to all the documentation on the students' removals and be aware of the IEP data. We also recommend having staffings before MDR meetings. I think it's good just so that all of the staff, the committee members are on one accord about what the student's conduct was and, was the student's IEP implemented. But of course, we do not want to do any kind of predeterminations at a staffing meeting. So the purpose of a staffing isn't to determine whether the student's conduct was a manifestation of their disability. Rather, it should just be making sure we have all of our documentation in place to prepare for the meeting. So when we're considering information at the MDR meeting and what should be discussed, the law requires certain relevant data that must be considered, such as the IEP, teacher observations, and input from the parent. So when conversing with the parent at the MDR meeting, it is best practice to get as much information as you can from them, such as recent changes the student has experienced. They might have lost a family member who was close to them or a friend. Are there any new medications the child is taking? And just different family circumstances that might be impacting their behavior. Maybe there is a new medical diagnosis or a hospitalization the child just went through. These are the kind of factors you would want to get from the parent when we're talking about the child's conduct. Note also that once the MDR meeting is convened, it is not the role of the MDR team, but of the investigating official or administrator to determine the conduct that is at issue. So we're not there at the MDR meeting to revisit, did the student violate the code of conduct? What exactly? Yes, we will talk about the conduct, but as far as disputing the facts of it, that is not the appropriate placement at the MDR meeting. And so sometimes parents will challenge the conduct at issue, but I think it's fine and reasonable to just say, that's not our purpose here. That's beyond the scope of the MDR committee. The administrator looked at the behavior data, made the proposal, and we are just here to make our decision as an MDR committee. Other relevant data to look at is maybe the student's evaluation data, such as their FIE or an FBA. We want to look at their discipline history, details of the incident, any recent changes in mood, that sort of thing. And be sure to include in the deliberations of the minutes what data the committee considered, so there's no question that the relevant and necessary data was discussed and considered. When including this information in the deliberations, try to be as specific as possible, rather than just saying the student has had recent changes in mood and behavior. Describe what those are. So, for example, you can say, parent reports that the student has become more aggressive when she doesn't get her way. Teachers have observed similar behavior on this day, this day, this day. That's the level of detail you want to include in your deliberations to reflect thoughtful conversations that the committee had. So IEP questions to be discussed at the MDR meeting. We also want to look at, was the IEP implemented? Have the services been provided consistently? Does the IEP address the student's needs? Maybe it needs to be updated. Are there behavioral goals and objectives in the IEP? This one is important because I think sometimes students' behavior changes throughout their years and as they go through puberty. And so it's sometimes shocking to campuses when they see a student who's generally been well behaved and then all of a sudden starts having behavioral issues. In a circumstance like that, you might want to consider including some behavioral goals if there aren't any in the IEP. So those are the kinds of questions that need to be considered thoroughly at an MDR meeting. Okay. So there are two questions that have to be discussed at an MDR committee meeting. I know we've just went into, all the different information and data you want to look at, but these two questions are very important to answer and are required by law. So the first question is, was the conduct in question caused by or did it have a direct and substantial relationship to the child's disability? And then the second question is, was the conduct in question the direct result of the district's failure to implement the IEP? And I want to talk about that second one because as schools, it's hard for us to sometimes answer yes to that question, right? I mean, we want to say we definitely implemented the IEP and did what we were supposed to, but that's not always the case. So for example, let's say we had a student whose BIP required him to be sent to the counselor whenever he had classroom outbursts. And so the student starts throwing books in the classroom and is just throwing them and throwing them. And once he does that, the teacher removes him to a cool down area in the classroom. So the student goes to a cool down area and then assaults another student in the classroom. After the assault, let's say the administrator proposes to suspend the student for 20 consecutive days. In this instance, there may be an argument that the district failed to implement his IEP. The reason is because the BIP said that the student is to go to a counselor once his behavior escalates. And so in that instance, when the student started throwing books, the parent could argue, hey, that's the point where you should have sent my child to the counselor. There might be other past incidents where the counselor was able to de-escalate the child, and that is why that accommodation is in the BIP. And so the parent could say, had you sent my child to the counselor, he never would have assaulted the student after throwing all of those books. So that's just an example of how this issue could come into play. And so just be mindful of that because that is an argument that you may hear from parents. And more importantly, we want to make sure we're, showing due process to the child. So if the IEP was not followed appropriately, we would want to address that. So next, Rebecca will kind of talk about what we do when the answer to that question is yes or no.
Yeah, thanks, Ashley. That's a lot of good information, and I want to emphasize really getting all of that stuff together before you actually come to an MDR, because I've been to so many MDRs where you have staff administrators who show up. Administrators show up and they have two different stories regarding what happened. So you need to be consistent and have a good understanding of what actually happened and why you're here. So that's really good. So let's say you come together, you answer those two, that first one of those questions, yes, that it was a manifestation or it was a failure to implement the BIP. If the answer to either of those questions is yes, the conduct shall be determined to be a manifestation of the child's disability. And to be a manifestation, the conduct cannot have an attenuated association such as low self-esteem to a child's disability. I've been in MDRs where you have a child with ADHD and they'll, maybe they have an LSSP, a private LSSP show up, and they're like, well, every poor decision my child makes is a manifestation. Without actually looking at the behavior, how the particular conduct manifests how the student's disability manifests itself. I think you really have to explore these, delve into what does the disability look like in the classroom, and not just jump to the assumption that, oh, it was a poor decision, so yes, it was a manifestation. That's not true. So you really have to look at those and provide a rationale for your decision in the deliberations, and of course put together a solid prior written notice. If the committee finds that the behavior is a manifestation, the IEP team has certain requirements. You have to conduct an FBA and implement a BIP if that hasn't been done previously. If there is a BIP that exists, you'll want to review that BIP and modify it if necessary to address the behavior. This is something that we find ARD committees sometimes overlook. Though the IDEA doesn't require that the BIP be changed merely because the student's behavior was a manifestation of the disability, the committee should at least consider it. So you're going to want to consider that whether or not change is needed, and document that in the deliberations. Or perhaps maybe the committee has observed a new behavior from the student and determines that the IEP doesn't adequately address those behaviors, or maybe the existing antecedents in the BIP don't align with the behaviors as the committee originally thought, and in those circumstances the BIP may need to be changed. Regardless of whether the BIP is changed as a result of the student's conduct being a manifestation of their disability, the committee should note in the deliberations that there was consideration and discussion about that. And finally, you'll have to return the child to their placement unless, and we're going to talk about this, the parent and the district agree to change the placement as part of a BIP modification, or unless one of the 45-day removal provisions apply. That's what I call the DSW exception, and we'll talk about that now. So even where the behavior isn't a manifestation, the student should still receive as appropriate an FBA, behavior intervention services, modifications designed to address the behavior so that it doesn't reoccur. The ARD committee must also determine that FAPE can be provided in the alternative setting. The student must be able to continue to participate in the general education curriculum and progress toward meeting the goals set out in the student's IEP. This does not mean that the student receives the exact same services in exactly the same setting as before the discipline. That is not the requirement. The education department has said that it doesn't interpret the term participate to mean that a school or district must replicate every single aspect of the services that the child would receive in his or her normal classroom. So when you go back and think about that Randy M case, you're not going to be able to replicate the services, but if you can check all those boxes, that the child was accessing his IEP, making progress on his IEP, and was being educated with his non-disabled peers, if you can check all those boxes, that's not going to count as a day of removal, but you're certainly not replicating every aspect of the services that the child would normally receive. And just make sure that the ARD committee adjusts the child's IEP to reflect what will be provided in the discipline setting. We've discussed the importance of training staff to ensure that they analyze data to make good, legally defensible MDR decisions. And with that in mind, remember that these are the three circumstances I referenced earlier where the IDA allows us to ignore the outcome of the MDR committee's decision if that behavior is a manifestation of the student's discipline. So under those circumstances, we can still remove the student to a discipline setting despite concluding that the conduct was a manifestation of the student's disability. So you still have to go through the MDR process and answer those two questions, but regardless of the answer, even if it's a manifestation, if one of these exceptions apply, and this is what I call the DSW for you ladies who love shoes, drugs, DS, serious bodily injury, and weapons. Okay, so that's my acronym for remembering those. So only applies to those three circumstances, very, very narrow. These are the three areas where student behavior poses a serious risk to self and or others, and where the IDEA has provided an avenue for immediate relief of 45 removal days. But you do have to continue to provide FAPE during those 45 days. Again, critical that you not skip the MDR meeting just because you suspect that the conduct falls into one of those three exceptions. The results of the MDR will just govern whether additional disciplinary time can be added. So if not a manifestation of the student's disability, we know that regular discipline applies to the kiddo, and you can assign, X number of DAP days, whatever you would assign to your general ed kid. But in the special circumstances before you, the DSW, that's going to be 45 school days. So it's also important to remember that even though we can discipline a special education student under these circumstances, we still want to consider updating the student's BIP if their conduct under these three exceptions is a manifestation of their disability. So you want to still go through that process. The first exception allows the committee to discipline a special ed student for 45 days if the student has carried or possessed a weapon on school premises or at a school function. That one's pretty easy to interpret. The IDEA requires us to look at another federal law for the definition of weapon, and that definition is here. It's a weapon, device, instrument, material, or substance, animate or inanimate, that is used for or is readily capable of causing death or serious bodily injury, except the term doesn't include a pocket knife with a blade of less than 2.5 inches. The weapon talks, this is again the definition, includes a firearm defined in part by federal law. You guys can read this on your own time, but you want to consult this definition anytime you're determining whether or not this special exception applies. So if the MDR committee determines that the conduct of bringing a weapon was a manifestation of the student's disability, again, it's going to be the discipline will be for 45 school days. If not a manifestation, then you can discipline for 45 school days plus whatever additional general ed consequences there are for that violation. These are a few cases that provide examples of what does constitute a weapon for purposes of the limited exception. Metal awls, which is a metal spike 2 inches long, that's a weapon. Scissors qualified as a weapon in this case, but you'll see on the next slide, it depends on the type of scissors, right? It's not those scissors we used in first grade that have the dull blades and can barely cut a piece of paper. Cigarette lighter with retractable blade, that's a weapon. And in the last case, the district properly placed a student with a learning disability in a discipline setting when the student possessed a knife 2.5 inches long when measured from the handle to the point of the blade. So that kind of helps you understand how to measure the knife if you get one of those cases. Not a weapon, pulling on the assistant principal's necktie. I mean, really, there's nothing involved that would be traditionally considered a weapon here or in most of these cases. I mean, a paper clip, scratching a student with a paper clip, stabbing a classmate with a pencil. I mean, that could do serious damage, but not a weapon in that case. And then dull scissors, like those we used in elementary school. What about the Gun-Free Schools Act? This is a federal law that requires states receiving federal money under the Elementary and Secondary Education Act to have a state law to expel for at least a year any student who brings a weapon to school. It does not override the procedural protections of the IDEA. It makes that very clear. So If the MDR determines the behavior was not a manifestation of the disability, then the student is expelled. If it is a manifestation of the disability, then your general IDEA procedures are followed. Also, the Gun-Free Schools Act allows the district's chief administrative officer to review and modify the expulsion on a case-by-case basis. But that only applies if the modification is in writing. The second exception for an automatic 45-day removal, despite the conduct being a manifestation, is the infliction of a serious bodily injury. This is rare. Serious bodily injury is just that. It's serious, as you'll see from the examples. It's defined as a substantial risk of death, extreme physical pain, protracted and obvious disfigurement, losing legs, losing, something, your organs are no longer functioning. I mean, it's like being on your deathbed, and you can see it is one of the hardest to interpret. Most simple assaults are not going to qualify. A principal with a broken nose, that doesn't qualify as serious bodily injury. A swollen knee after a student kicked the principal, not going to qualify. It really is something that's going to require at a minimum some time off work or school or hospitalization. And I think when you're trying to determine whether an injury is serious, those are the kind of questions you want to ask. Was there hospitalization? Was medical treatment required and follow-up required? Multiple days away from school or work, because we know one day away isn't going to do it. Was physical therapy required to regain use of the affected body part? So those are just some things to help you get through that. And we're running low on time, so I'm going to let you all read through this case on your own time. But again, in this case, she described it as the worst pain of her life. She missed a week's worth of work, extreme physical pain. I mean, that might qualify as a serious bodily injury. So again, those questions that you ask, if you're answering yes to those, then that's gonna probably indicate that it was a serious bodily injury. The third exception for an automatic 45-day removal, despite it being a manifestation, is the possession of drugs. The district can remove the student if the student is possessing or using illegal drugs on school property or at a school function. So this would apply to a student at a football game or a school dance or just during the school day, and that one's pretty straightforward. As you see, the IDEA again refers us to another federal law for defining a controlled substance. That's a drug or other substance identified under the Controlled Substance Act, and you can, I believe there's a list that you can consult. You can look at that. So be sure to check that out when determining whether the student has brought a controlled substance. We know that many students are smoking vape pens more frequently on campus. A vape pen that only has tobacco in it would not fall under this 45-day exception, but if the student has marijuana in that vape pen, then the MDR exception would apply. So hopefully your district is equipped with those handy tests that can tell you immediately if it's containing marijuana or some illegal substance. And I'm going to hand it over to Ashley.
Alrighty. So when the threatening behavior is a manifestation and none of the three special circumstances apply, what do we do? Just kind of a recap. The IEP team is to conduct an FBA and implement a BIP, or they can review the existing BIP and address behavior as necessary, and then they must return the student to the placement unless the parent and district agree to change as part of the BIP modification. So that's just kind of a recap of what we do when none of those three exceptions apply. So we have talked about the MDR process in the context of special education students. However, the IDEA also requires districts to convene an MDR meeting when there is a basis of knowledge that the student may be eligible for special education. And the law is very specific in defining what that basis of knowledge means. And so this is really about students who we suspect to have a disability. And how do we determine if the district had knowledge? One, maybe the parent expressed concern in writing to a supervisor or administrator personnel, or a teacher of the student. So notice how specific it is. If the parent made some concerns to the attendance clerk, for example, that wouldn't be deemed as the district having knowledge. It's very specific about who those concerns have to be made to. Secondly, if the parent of the student requested a special education evaluation of the student and that was pending, that would be considered deemed to have knowledge. The district had knowledge. And third, if the teacher of the student or other personnel expressed specific concerns about a pattern of behavior to the director of special education or other supervisory personnel, such as an administrator. So again, similar to one, the teacher's reports have to specifically go to certain individuals. And so if any of these three factors are triggered, then the MDR process is still required. And I think it's really easy for districts to forget about this because we usually just think about the kid who has already been qualified for special education. But again, if there's a suspected disability based on any of these three, then we would need to do an MDR. So there are some exceptions to that basis of knowledge, and those include if the parent of the student has not allowed a special education evaluation of the student or has refused special education services. So in any of those instances, the district would not be deemed to have knowledge that there's a suspected disability, and that's because of the parent's refusal. And secondly, if the district has conducted an evaluation and determined that the student is ineligible for special education. In those instances, we would not say that the district had knowledge of a disability, so you would treat the student just like you would a general education student because there's not this suspected disability. So we have a couple slides here about this whole issue about suspected disability. I'd love to go through them all, but we are running low on time. I really think it's important to look at them. Specifically, the second one was interesting. I'll say real quickly in that one, the district was deemed to have knowledge because there was a pending request for an IEE at the time the student was suspended to go to DAEP. And so the district did their evaluation, found the kid ineligible, parent went and got an IEE. Because of that IEE, that's why the hearing officer said that the district had knowledge of a suspected disability. Had the parent not gotten the IEE, then again, we would have said that there was no basis of a suspected disability. So just keep that in mind. These are some child find cases, then the next slides that we'll go through. Under the IDA in Section 504, you know that we have an obligation to identify, locate, and evaluate students with special education needs. And it's really important to look at that from a behavioral standpoint too. I think a lot of times we look at it from an academic standpoint, but if you have a child who has frequent complaints about their behavior, they're having excessive restraints by staff members, excessive disciplinary referrals, we should be thinking about whether the child is eligible for an IEP or a 504 plan. So always be thinking about that and educating your staff about our child find obligations. And these are some child find cases specifically about kids with behavioral needs. Again, we won't go through all those facts today, but important to just keep that obligation at the forefront of your minds. Okay, so what else can be done to deal with a student who is dangerous? So the parent in the district can agree to a change of placement. Maybe the student needs to go from a general education room to a PASS class, maybe from a PASS class to a behavior class or to a self-contained behavior class. When we're making those decisions, we always want to think about the student's least restrictive environment, but there are circumstances where the child's behavior is just so aggressive and out of control that a more restrictive environment is necessary. If the parent does not agree to a change of placement, all of you know we have, under our state law, we have to do a reconvene meeting within 10 school days after the disagreement. And then at that reconvene meeting, if the parent still disagrees, but the school-based committee members agree that a change of placement is appropriate, then the ARD committee can proceed. Make sure you have detailed prior written, or you give the parent a prior written notice, and that you have detailed deliberations. This is an example of where you'd want to say why the student's current placement is inappropriate. Don't just say that it is. inappropriate, explain why it's not. Then talk in detail about why the new proposed placement would be better for the student. So make sure all of those details are in the deliberations, and also note the parents' disagreement within the deliberations as well. Okay, so other ways to address is through a change of schedule or location, but not necessarily placement. You can move the student to a different class, away from a student he or she has threatened. Transfer the student to another campus. Transfer the bully, who was a special education student, to another campus, and our education code goes into that. And so with these examples, again, we're not changing the student's placement. As we talked about earlier, we're changing placement when we're actually transitioning to a completely new setting that maybe changes the types of services they receive. Here we are not doing that. We're just simply maybe changing the kids to a new campus. Of course, ensure that they're still receiving all of their accommodations within their IEP. Another possibility is to address it with a threat assessment, as Rebecca spent a lot of time discussing earlier.
Too much time.
And then making sure we're adding different services in the student's IEP if needed, such as providing the student with counseling, psychological consultations, music therapy. Maybe the child needs a one-on-one. Whatever it may be, we want to try to think about what services we can add into their IEP to ensure they're accessing FAPE. Okay. Other options the school district has is to address it with a hearing officer if a student's behavior is that out of control. In these instances, a hearing officer can place a student in an appropriate interim setting for not more than 45 school days if the hearing officer determines that maintaining the student's current placement is substantially likely to result in injury to the child or others. And so this is a potential remedy that the districts can have if the behavior is so out of control and the parents not agreeing to a change of placement. And I think of this almost as like emergency relief that the district is seeking. So in these cases, the district has the burden of proof, and the district must prove that the student is a danger to themselves or to others. It's a very shortened timeline if you are to request this hearing. Know that TEA will arrange for an expedited hearing. It's to occur within 20 school days of the date the hearing is requested, and then the hearing officer has 10 school days to make a determination. So these timelines are very, very short. If you do decide to proceed with these hearings, you have to make sure all of your evidence is together, that teachers are prepared to take time out of class to prepare for testimony and to testify at the hearing. So it's an intense time period, but this is something that a school district can do when they are in an emergency situation.
And that's the same timeline that's going to apply to when the parent disagrees with the MDR decision. So you're not going to get your 10-day recess after the MDR. You're going to jump straight to, if the parent disagrees, they have the right to file for an expedited due process hearing with that same timeline.
Exactly. So these are just some case examples where a student was extremely dangerous and the districts attempted to seek this relief from the hearing officer. In this case, the student put his hand through a glass window, repeatedly threatened students, teachers, and the principal. The hearing officer allowed the district to do a 45-day removal in this case. Skip over a little bit because of our time. Okay, and so in this case, another 45-day alternative placement where the school district tried to request this from a hearing officer. Here, the student had ordered a crossbow and 2 knives on his school computer, and he also had over 100 images of pornography on his computer. And some of the images involved children, little toddler children. And so prior to this, prior to the district seeing any of this, the kid had really good behavior. and they just really didn't have any issues with him behaviorally. But when the district found all of these porn images on the computer and saw that the student had bought a crossbow, it requested the 45-day alternative placement. And the hearing officer actually ruled in favor of the parent and student and said, no, this child, this does not rise to the level of substantial danger. Obviously, what the student did was inappropriate. He actually spent time in juvenile detention as a result of the child pornography that was found on his computer. But the hearing officer said that there was no evidence that the student was trying to show those images to people on campus or trying to sexually expose himself. And again, there was no history of violence, of him bringing weapons to school. The kid testified that he really enjoyed camping, and that was why he ordered the crossbow. But it wasn't he had no intentions of endangering anyone. Okay, next, Rebecca will talk about reports to law enforcement.
Okay, so we've talked about a lot of options for addressing student behavior. Another option is to report the student to law enforcement. I wouldn't make this your go-to option. I think some schools do this happily. It doesn't prohibit. IDEA doesn't prohibit you from calling law enforcement, and you don't have to notify parents or the ARD committee before doing so. But you have to think about other laws, including FERPA, when you do this. You'll want to probably consult your legal counsel because there are some confidentiality concerns concerning sharing students' BIP and other information. And we've been asked about BIPs and whether or not to include contacting the police in a student's BIP. This isn't something that we would advise putting in a BIP. You have a right to contact the police whether it's in a BIP or not. So there's really no reason why you would want to do that. So remember that if a district reports a crime, the district must provide copies of the special ed and discipline records of the child. Here's the law that addresses that. We're out of time, so finally, if all else fails, there's the health and safety exception in FERPA that is addressed on this slide, and we hope you got a lot of great ideas from this presentation. We're sorry we couldn't go into as much detail as we wanted to, but if you have questions, we'll stick around. We'll be happy to answer those. Thanks.
Thank you very much.
Thanks. Hope you're enjoying TCASE.
Bye, everyone.
Bye.